Your Lordship's permission.
Yes, who wants to mention?
Yes, my Lords. With your Lordship's kind indulgence, I have to inform one thing, my Lord. This particular matter was listed yesterday before the Honorable Chief Justice Bench, where this Honorable Court has directed now that this matter will be heard by my Lord, because this particular matter was last heard by my Lord on 18th. I was there in this, my Lord's Ranchi High Court physically. So this is now, my Lord, is directed to be listed before your Lordships. Number one. And number two, my Lords, my request to Lordships there, that the court also permitted me liberty to mention today, and with kind permission of my Lord, may this particular matter may kindly be listed tomorrow, my Lord, physically, and so that I can come up.
Yes, Land Council, you see the order of assignment, etc. is communicated through the registry internally to our court master and staff. So we will inquire about your mentioning. But so far, that assignment order is not passed on an administrative side. We won't be able to entertain your request for mentioning as of now. You can send your slip. It will keep lying. But only once the administrative order of assignment is passed, then we can fix any date.
My Lord, this is a judicial order. Just for the information of my Lord, this is a judicial order. Your Lordship's Chief Justice also permitted me, and that to mention and inform to this Honorable Court. That is the reason why today I am informing. Number one. Number two, my Lord, regarding the date, if it can be date. I mean, I understand what my Lord is indicating to me. But besides that, my Lord, I also will send the memo also, and then if not tomorrow, then another date, my Lord, may kindly be noted that 6th of May at least, not before that, my Lord. At least on 6th, if your Lordships can indicate that.
6th of May being a Friday, we are not sitting in division.
Oh my Lord. Then, my Lord, on 11 then, on 11. On 11.
Okay, then we'll see. You can give your alternative dates.
Yeah. I only request if it can be done tomorrow. I am so eager to come over, my Lords, to appear before my Lords. And this is an urgency I am only requesting for tomorrow. Otherwise, it will be too late, my Lords.
You please send your list. We will inquire.
Yes, my Lords. Yes,
and then give an appropriate date.
So much obliged, Lords. So much obliged. Thank you for your kind indulgence.
Lordship, may I mention one case, Lordship?
Yes.
Lordship, one criminal appeal DB 884 of 2014. Lordship, this IA for bail of the appellant has been rejected on 24/9/2021, and the Lordship has directed to renew the prayer for bail when the appellant complete the total period of 10 years of his custody, Lordship.
Mr. Kashyap, is this matter which you are mentioning a tied-up matter of this bench or some
Lordship, no, Lordship, the Lordship, along with Honorable Mr. Justice Bhengra, Your Lordship.
So in that case, in first place, you ought to seek leave of Honorable Brother Judge to mention it before Miss Singli today. And otherwise also that you did not have mentioned. If you give the slip to the court master, he takes care of all that.
Lordship, I'm sorry, Lordship, for that, but I have already mentioned this case. Therefore, Lordship, I'm sorry, Lordship. I seek apology for that, Lordship. I seek apology. I seek apology. I'm obliged.
Yes.
May I mention a case, Your Lordship?
Yes, please.
Your Lordship, criminal appeal SJ 253 of 2022, Your Lordship.
Mr. Rukma, have you not heard my observation to Mr. Kashyap on a mentioning of a matter which is not of this bench? There is a particular procedure and a courtesy to be accepted. And a matter is mentioned before one of the judges of the division bench, of which the other honorable judge is not a member.
Your Lordship, this is single judge, Your Lordship. This is not DB matter, Your Lordship. The matter related.
थोड़ा सा पहले
Your Lordship, I'm sorry, Your Lordship.
कोर्ट का प्रोसीजर, प्रैक्टिस, कन्वेंशन सीख लीजिए अपने सीनियर से, अपने सिस्टर ब्रदर से। आप जब
I'm
भी
sorry, Your
मेंशन
Lordship.
करेंगे ना डिविजन बेंच में, जिसमें कि ब्रदर जज उस बेंच के पार्टनर नहीं है, जिस मैटर को आप मेंशन कर रही हैं, तो पहले
I'm sorry,
ब्रदर
Your
जज से परमिशन लेना चाहिए कि हम मेंशन करें, क्योंकि इट्स ए डिसकर्टसी टू द ब्रदर और सिस्टर जज, एंड आई कैन नॉट एंटरटेन अनलेस हिज लॉर्डशिप परमिट्स मी टू। ये सब थोड़ा थोड़ा माइनर कर्टसीज जो है ना, प्लीज एंड थैंक यू जो कहा जाता है इंग्लिश का, वो सब थोड़ा सीख करके पहले करना चाहिए। डोंट टेक एनीथिंग फॉर ग्रांटेड व्हेन यू आर अपीयरिंग बिफोर ए कोर्ट। Otherwise, my advice to you, you can pass on the slip to the court master. He takes care of all this. Yes, call the list.
From the Delhi College for orders with defect. Item
Yes.
Item 2, LP number 348 of 2019, Mr. Samvesh Manjdev for the
Your Lordship, I am appearing in this matter. Your Lordship, I was praying for 3 weeks' time in this matter to remove the defects.
Not
Your Lordship.
audible. What do you want?
Your Lordship, I was praying for 3 weeks' time to remove the defects.
This is a 2019 matter. Why have you not taken steps?
My apologies, Your Lordship. We'll remove this defect.
You should not neglect brief of your office. The client sometimes get disappointed and takes away the brief for these all reasons only.
Yes.
लगता है कि मेरे केस को ध्यान दे रहे हैं, लिस्ट हो रहा है, लिस्ट हो रहा है. Ultimately, as a counsel, you suffer. Frame 3.
Obliged, Your Lordship.
Obliged, Lordship. I was appearing for this state.
item 3, LP number 354 of 2019, Mr. Sanjay Kumar Tiwari for the applicant.
ये भी 2000.
Your Lordship, praying for 3 weeks' time to remove defect.
Three weeks, frame 3.
Obliged.
Item 4, LP number 388 of 2019, Mr. Jasankar Tripathi for the appellant.
Lordship, in serial number 4, I am appearing on behalf of my senior, Mr. Jaisankar Tripathi. Actually, some defects of this file have remained unremoved, and therefore it's my humble prayer for grant of 3 weeks time for removal of the same, sir.
हम लोग आवाज नहीं सुन पा रहे हैं ठीक से, आप थोड़ा जोर से बोलिए या कुछ अपना माइक
Your Lordship, I am appearing on behalf of my senior, Mr. Jaisankar Tripathi, in this matter, Your Lordship.
What do you want?
Your Lordship, some defects have remained unremoved. Therefore, I need 3 weeks time for removal of the same.
How much time?
3 weeks time, Your Lordship.
3 weeks.
I am a chairman of constituency minus 1.
Very well, send your slip.
Yes.
Item 5, LP number 395 of 2019, Mr. Samir Saur for the appellant.
Yes, Mr.
About 2 weeks time.
2 weeks peremptory.
Item 6, LP number 442 of 2019, Mr. Parvez Ahmad Khan for the appellant.
My lord, in this case, I pray I have not removed the defects, my lord. So far, my information is concerned, my lord, the appellant was suffering from corona. So, let 3 weeks time may be given, my lord, to locate the appellant, my lord. What is the real position? It is not informed to me, my lord.
3 weeks time peremptory.
Peremptory, my lord, locate करना पड़ेगा.
नहीं तो आपको पहले टाइम मिल चुका है.
जी मिल चुका है और उसके बाद उस वक्त से हम उसको लोकेट करने की कोशिश कर रहे हैं, लेकिन कोई लोकेशन हमको पता नहीं चल रहा है. फिर भी हम
आपको
जी 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 जी
टाइम मिला था मिस्टर काउंसिल
जी.
अब तो सब नॉर्मल लाइफ चल रहा है, इसलिए 3 वीक्स टाइम परemptory.
अब लाइक
डिफेक्ट रिमूव करिए अपने स्तर पे.
वो तो मैं करूंगा, लेकिन हमको पता नहीं चल रहा है व्हाट इज द पोजीशन. ओके, ऑलराइट.
Item 7, TA number 14 of 2021, along with item number 8, Mr. P.S. Pati or the appellant.
My lord, in these two cases, my lord, initially they were filed through email. Email filing was done, and then the physical copy was also filed. My lord, by mistake, what has happened that the physical file of the email filing has got interchanged. There were 2 tax appeals, my lord, by the same name. Party position was same. So the physical copy and the email filing copy does not tally with each other. This is the defect by the office. So I have, it's a judicial order is required, my lord, for placing interchanging the petitions. So I have filed 2 IAs in both the cases, separate introductory applications, making this clear.
After the last order, when we gave you permission to remove that defect, you do not appear to have filed any inspection slip or done anything to remove the defect.
Well, we inquired with the office. They said that without a judicial order, we will not allow you to permit to interchange the petitions because those are matter of record.
There is nothing in the office note to that effect.
My lord, for that reason, I had filed the IA, my lord. Due to that reason only, introductory application, making that clear.
both the appeals suffer from the same defect, which is as under. Winner. Stop. They have been tagged together as they relate to same issue vis-a-vis the same assessment. Respondent assessment. Stop. The nomenclature of the hard copy file has got interchanged with the soft copies of the respective appeals. In order to remove that defect, earlier time was granted, but then counsel for the appellant, Mr. P.S. Pati, submits that unless such a direction is issued to the office, the respective appeals have already been issued, their memo cannot be interchanged. Stop. IA number so and so has been filed in the respective appeals with such a request, with such a prayer. Stop. Para. In the light of what has been stated in the IA on a consideration of the submission of learned counsel for the appellant, in order to resolve this intractable issue, learned counsel for the appellant is required to undertake due diligence in the presence of the authorized court official and get the respective memo of appeal interchanged with the other one so that they tally both in the e-filing number as also the hard filing number. Stop. 2 weeks time is allowed for the said purpose. Respective IAs are accordingly disposed of.
Obliged, my lord.
Office to cooperate, respective IAs are accordingly disposed of.
Obliged.
Call to the नहीं ये वाला सप्लीमेंट्री में है ये सारा 2011 का एंट्री टैक्स का वायरस सब चला गया कुछ लोग पास किया होगा ना उधर से बोले बचाओ भाई हाँ
From the supplementary list under the heading for admission, item 1 WPT number 3775 of 2017, along with item number 2 to 76. Mr. Sumit Gaudia for the
These appear to be entry tax matters, my lord.
Right.
The ultra.
So this will be heard by the other division bench where the virus.
Yes. Yes, my lord. It has the virus matters, my lord.
Since the virus of the section 3 and section 2K and section 3, these are the two provisions.
Yes, of the Jharkhand Entry Tax Act 2000, the Act 2011, and there is another act, my lord, the section 11 Jharkhand Value Added Tax Act.
Value added also.
Yes, my lord.
In the first writ petition, which is 3775,
Yes.
it's only 2K and section 3 of the Entry Tax 2011.
Yes, my lord. That was the subsequent Entry Tax Act, which was under challenge, which was also declared ultra virus. Prior to that, there was a provision in section 11 of the Jharkhand Value Added Tax Act, which also provided for levy of entry tax. That was also declared as ultra virus. So the batch relates to both the writ petition, both kinds of writ petition.
You give a short one paragraph because we won't be able to scrutinize each one of them. But
Yes.
basically, the relevant provisions you please indicate in a short paragraph.
I'll dictate. Yes, I'll dictate that relevant provision under challenge.
Since the virus of the Jharkhand Entry Tax within bracket on Consumption of Use of Goods Act 2011, some of the provisions of so and so and so, जो लिख के भेजेंगे, are under challenge in the present batch of writ petitions. Let the matters be placed before an appropriate bench as per the present distribution of roster.
Sublime.
For orders from the daily policy. For orders, item 9, first appeal number 12 of 2020, along with item number 10, Mr. Mahesh Tiwari, Mr. Siddharth Rai for the appellant.
May I please your lordship in this matter, my lord? Am I audible, my lord?
Mediation has failed.
Yes, my lord.
Let both the appeals be admitted now. Respondent has appeared in both the appeals.
Yes, my lord.
Yes.
Well, the first appeal we are the appellant, and the second we are the opposite party, my lord. That is serial number 11.
Mediation has failed as per the report of learned mediator.
Serial number 9 or 10?
2270 dated 7th October 2021.
My lord, I am appearing in serial number 9 or 10.
Very well. Send your appearance slip. Both the appeals arise out of the common impugned judgment. Stop. Admit. Call for the lower court reports in connection with so and so from the court of so and so.
We are obliged.
Place the matters under the heading for hearing. Appeals under the heading for hearing as per on the seat of the LCR as per its age.
Item 11, first appeal number 19 of 2020, Mr. Shankar Singh for the appellant.
My Lordship, I am appearing on behalf of the appellant, my Lordship. My Lordship, last occasion, my Lordship, I have granted 2 weeks time to take a step for substituted service of notice. My Lordship, but it could not be taken a step. Therefore, my humble prayer, my Lordship, kindly allow me 2 weeks further time to take steps, my Lordship.
2 weeks more time as prayed for is allowed to learn
Yes.
for the appellant to take steps for substituted service of notice on the respondent, failing which this appeal shall stand dismissed without further reference to the bench.
For admission, item number 12, serial number 32 of 2020, along with item number 13 and 14, Ms. Amrita Sinha for the appellant.
Your Lordship, in these cases, notices need to be sent, Your Lordship, issued.
You have to file affidavit because the tax effect appears to be lower than 1 crore.
Yes, Your Lordship, the case is arising out of the acceptance of audit objection. I will be filing that relevant documents in this matter, Your Lordship, but showing that it has been accepted by the department and therefore fall within the exception clause.
Then counsel for the appellant undertakes to file affidavit with respect to the issue whether the tax effect of the disputed amount falls within the monetary limit for preferring an appeal before this court, or it falls within any of the exceptions to the CBDT circular. 2 weeks time?
Yes, Your Lordship.
2 weeks time as prayed for is allowed in all the appeals.
Obliged.
Item 15, WPS number 1787 of 2020, Ms. Leena Mukherjee for the petitioner. Mr. Gautam Rakesh, Mr. Prasanna Pallu.
Yes.
Mrs. Paul, please wait for some time if you can.
Yes, sir. Yes, I get it.
My lord, serial number 15.
Just we'll call again. We are taking up some other matters where adjournments, etc.
Yes,
My
sir.
lord.
Both of you are prepared in this matter today.
My lord.
Very well.
Item 60, WPT number 3022 of 2020, along with item number 73.2. Mr. Kumar Prasad for the petitioner, Mr. Ashok Kumar Yadav, Mr. Sachin Kumar for the respondent.
If it may please your lordship. Your
Yes.
lordship, in this matter, I have circulated an email that these matters may be heard in physical mode, your lordship.
For adjournment, for what purpose?
Your lordship, the pleadings in the matter are complete. I was praying that these matters may be taken up in physical mode.
In the physical court?
Yes, your lordship.
Pleadings are complete?
Your lordship, so far as 3 matters are concerned, and those matters they are complete. Only 2 matters are the joiner is ready. We'll be filing it in a day or 2, your lordship.
It doesn't appear that their defects have been removed, of course. Counter. And counter affidavit is also there in all the connected
Yes,
matters.
your lordship. Yes, your lordship.
Rejoinder, yes, एक में नहीं है rejoinder.
Your lordship, in 2 matters, the joiner is not there.
Then counsel for the petitioner, Mr. Siddhi Jalan, has prayed for an adjournment to file rejoinder affidavit in WPT number 463 of 21.
Yes, your lordship. And WPT number 466 of 21. Serial number 17 and 18.
466, there is an endorsement that you have filed a rejoinder.
I'm sorry, your lordship, it was filed. Yes, your lordship. Only in one matter it has not been filed.
463.
Yes, your lordship.
She also prays that these matters may come up on any day when the court is functioning in physical mode. 2 weeks' time, as prayed for, is allowed to file rejoinder affidavit. The matter will be listed thereafter when the court is functioning in physical mode.
Much obliged, your lordship.
The rest of the matters, pleadings are complete.
Item number 21, first appeal number 41 of 2021, Mr. Nilesh Kumar for the appellant, Mr. Vishal Kumar Tiwari for the respondent.
Your lordship, I am appearing on behalf of the appellant in this matter.
Mr. Vishal
On
Tiwari, are
previous
you
occasion,
appearing?
your lordship, notice issued.
Mr. Who is for the respondent? बड़ा network affected है। सारे कोर्ट का ही पोजीशन है कि हम ही लोग?
Your lordship, name of Mr. Vishal Kumar Tiwari.
We can see that. We are asking anyone appearing so that we can send it for mediation.
The cause list.
Arjun Shikar. Grandmother and mother के पीछे. These are from Ranchi. By the impugned judgment, respondent has entered appearance on notice through wakalatnama. Stop. By the impugned judgment dated 27 February 2021, passed in so-and-so by the court of so-and-so, the suit under section 7 of the Guardianship and Wards Act 1896 and section 13 of the Hindu Minority and Guardianship Act 1956, referred by the plaintiff grandmother / respondent herein has been allowed by directing the custody of the minor girl Sneha Kumari from the mother / appellant herein to the grandmother. Stop. It is therefore, since the question relates to since the issue is of paramount well-being of the child, and the parties can resolve their differences amicably, it is deemed proper to refer them for mediation before Jalsa. Stop. Since the parties are from Ranchi, they can appear physically. Stop. As such, let the parties appear before the learned member secretary 6th of May 2022 at 10:30 a.m. Then member secretary Jalsa can also be approached on the following numbers. On their approaching the appearance, the matter be placed before London mediator for undertaking the exercise. Both the parties are expected to cooperate in the proceedings with an open mind and attend each of the sittings. Stop. If they are able to arrive at an amicable settlement, terms and conditions thereof be reduced in writing under their joint signature and be submitted along with the report 4 weeks thereafter. Place the appeal along with the report in the week of 13th June 2022.
Your Lordship, in this case, let my appearance be marked on behalf of respondent.
Yes, Mark, but you conveyed that she has to appear on 6th of May.
Yes, Your Lordship. Noted. Object, Your Lordship.
Item 22, WPT number 1051 of 2021, along with item number 30, 24, and 25. Mr. Sumit Gurung for the petition.
Next is Your Lordship, I am appearing in this matter. Your Lordship, these matters are similar to the issuance of show cause notice without no issuance of show cause notice and passing of the adjudication order, Your Lordship. Similar cases have been already listed on 5th May, Your Lordship. Requesting Your Lordship to tag these matters with those orders, those cases.
Learned counsel for the petitioner, Ms. Sanksha Mittal,
Yes, Your Lordship.
submits that similar matters are listed posted on 5th of May 2022.
Yes, Your Lordship.
Such as WPT number
3153 of 2020, Your Lordship.
3153 of 2020. So and so.
Yes.
As such, place the matter on 5th May 2020.
Obliged, Your Lordship.
Item 26, WPT number 1909 of 2021, Mr. Sumit Gurung for the petition.
My lord, in this case,
further instruction. Ms. Amrita, you had taken time to, on twice after your last argument in late March.
Once I have taken time.
To have more instructions or what?
Yes, Your Lordship, but I tried my best to obtain the instruction, but as the PCIT who has to give the information is bedridden and he is in Delhi in the hospital, Your Lordship, and therefore I could not get the relevant information. But as the last indulgence was written there in the last order, so I am not praying for any adjournment, and whatever instruction I have, I will be pursuing. He is not well, Your Lordship. The PCIT who has to take the necessary instruction, he is bedridden from last 10 days and he is there in Delhi. So therefore, I could not obtain the instruction as required for.
In view of the reasons that you have stated, we can give one more indulgence to you. Because whatever you had to argue, you had already argued on that.
Yes, Your Lordship. I have. In fact, I have today itself in the morning, I have also circulated some one mail, Your Lordship, in which the other judgments on which I will be relying and the PC Act, the before amendment and after amendment, all the things have been compiled in one mail and I have sent it to Your Lordships and to the opposite party also.
Mr. Kurmi, one more indulgence to the income tax lawyer.
No, it's good, my lord.
Ms. Amrita Sinha. Today on physical day or virtual day?
My lord, virtual, my lord. Kindly, my lord, virtual.
Ms. Amrita Sinha, Land Counsel for the Respondent Department, submits that since the PCIT is bedridden and undergoing treatment at Delhi, necessary instructions not be obtained, though the matter has been adjourned earlier on that pretext, on that ground. She prays for is allowed further 3 weeks' time to come with complete instructions, if any. The matter will list after reopening of summer vacation 2022 on any virtual day. The court is also fulfilling virtual mode, as requested by learned counsel for the petitioner, Mr. Karthik Kurmi.
Oblige, my lord.
Item 27, WPT number 3133 of Jharkhand.
My lord, I am appearing for the petitioner. The pleadings are complete.
Lordship, I am appearing on behalf of CDST.
यहाँ से वहाँ ये हम नहीं किए
नहीं यहाँ इससे कनेक्शन है और ये छोटे कनेक्शन उससे वर्क नहीं करेगा अब ये ऑफ की जगह तब हुआ इसमें प्रॉब्लम आ रहा है.
Are we visible on the screen?
No,
my lord.
No, my lord. The camera.
No.
It's not visible.
Not visible.
There is network issue at our end. Sorry. Councils, none of you were complaining that we are not visible.
Now visible, my lord.
Yes. So,
My lord, item number 27, tradings are complete.
both sides are ready today?
Yes, my lord.
In that case, we will take up shorter matters and then come back to it
My
in a
lord.
short time. Next call, please.
Item 28, WPT number 4710 of 2021, Mr. Sunil Gomez for the.
Your Lordship, I am appearing for the petitioner. Your Lordship, this matter pertains to reimbursement of the service tax discharged by the petitioner on behalf discharged by the petitioner on amount of the wages reimbursed to the petitioner by the respondent BCCL due to implementation of the mid-wages payment scheme. Your Lordship, pursuant to the letter of award dated 10/12/2012, Your Lordship.
Which is the relevant
Your Lordship,
clause in your agreement?
Your Lordship, clause 26 of the tender document.
No, in the agreement.
Of the tender document, Your Lordship, page 49 of the writ petition.
What is at page 85, clause 11, Roman 7?
Your Lordship, the clause 27 on page 50 specifies that the service tax will be extra if payable. Contract service provider will have to submit duly notarized affidavit or non-judicial stamp paper to the effect that the contractor has made payment of service tax in accordance with law. Such notarized affidavit with regard to payment, deposit of service tax of the preceding month should be produced by the contractor every time while making claim of the payment. So, Your Lordship, as per the tender document, the contractor was allowed to make claim of the service tax discharged by the contractor. However, Your Lordship, in our case, the BCCL, taking advantage of of their dominant position, has refused to pay the service tax. However, Your Lordship, subsequently the GST.
Learned Council, you are referring to the tender condition. Now there is an agreement between you. Why are you not referring to the relevant clause at 11? At page 85, clause 11, Roman 7. And page 86 at the top. And also the work order at page 116.
Yes, Your Lordship, I was trying to start with the facts of the case, Your Lordship.
Anyway, who appears for the CCL? Mr. Amit Kumar Das. You unmute yourself, Mr.
Sorry. Yes, for appearing for CCL in this matter. Notes, my submission would be, notes, the petitioner has made a claim before the general manager and the issue has still not been decided. So, my lords may remit back the matter to the general manager to pass an order on the claim of the petitioner so that he can decide the issue.
If it is as simple as that, then why should we entertain it at this stage?
Yes, my lords, page number 160, annexure 16. Annexure 16 is the...
Your Lordship, your voice is breaking, Your Lordship.
We are saying that if it is as simple as that, then we would not entertain it now. If it is rejected, then you can come back.
Yes, my lord, that is my submission. Page number 160, annexure 16.
Your Lordship, your voice is not clear, Your Lordship.
Kindly come to page 160.
Are we not audible?
Yes, my lord, your lordship.
It's audible, your lordship.
18 June 20. Annexure 16. Ms. Mittal's learned counsel, CCL is saying that you should first approach the general manager before whom you have represented, and he will take a decision. So we can dispose of the writ petition. She has disappeared.
Yes, yes.
ये लाइव स्ट्रीमिंग के चलते तो नहीं हो रहा है ना कुछ. Where has the petitioners counsel disappeared? Yes, Ms. Mittal. Unmute.
Apologies, Your Lordship, my connection was lost, Your Lordship. I could not hear anything.
So we can dispose it off for the general manager to take a decision before whom you have represented at Annexure 16, by Annexure 16.
Your Lordship,
Once he decides, either way, if you are aggrieved, you can appeal the court. And
Your Lordship, this will be of no use, Your Lordship, as we have made several representations and the CCL has refused to us.
we will ask them to decide within a time frame.
Your Lordship, if Your Lordship may pass over this case for one more occasion, Your Lordship.
Mr. Amit, we can fix a time frame for your general manager.
Yes, my lord. Your Lordship may give him 4 weeks so that he can take a decision. If the petitioner is agreed, my lords, they are always at liberty to approach this honorable court.
Very well.
Their point is that stay was granted only due to the corona situation. No, it was argued and thereafter it was argued and granted the matter not because of corona.
The writ petition has been prepared for the following reliefs. Then counsel for the petitioner, Ms. Kansha Mittal, has referred to the terms of the tender document at page 85, clause 11, Roman 7, and one of the work order dated 10th December 2012 at page 100, as per which the employer is bound to reimburse the increase in tax liability on production of documentary evidence in support of payments actually made to the concerned authorities. Stop. The increase in service tax has been entailed on account of the direction of the respondent CCL to pay enhanced rate of mid-wage payments to the workmen. Stop. Petitioner has discharged the service tax liability invoking the Sabka Vishwas within bracket Legacy Dispute Resolution Scheme 2019. But despite representation made, such as Annexure 16, to the General Manager, Central Coalfields Limited, Piperwar area, for reimbursement of the excess service tax paid on account of payment of enhanced rate of mid-wage payments. The respondents have not taken any decision. Stop. Then counsel for the respondent, Mr. Amit Kumar Sinha. And counsel for the respondent, CCL, submits at the outset that since the petitioner's representation has not yet been disposed of, considered and disposed of by the general manager, respondent number 4, Piperwar area, CCL, respondent number 4. For the present, the matter may be remitted to the concerned authority to take a decision in accordance with law on the basis of all materials and documents presented by the petitioner in support of his claim. Stop. On consideration of, then counsel for the petitioner submits that a time frame may be fixed as the respondents have not taken a decision despite repeated representations made from time to time. Stop. On consideration of the submission of learned counsel for the parties, we are satisfied that the writ petition can be disposed of with a direction upon the respondent number 4 to take a decision.
Can I submit
on the claim of the petitioner? Yes, Mr. Garodia.
Can it be to the headquarter level, because ultimately it has to be decided by headquarter to respond?
Yes, yes. To the competent authority.
Yes.
To the competent authority.
Maybe respondent number chairman come managing director or general manager sales and marketing, my lord.
It can be the general manager sales and marketing.
To the competent authority through the general manager, Piperwar area, respondent number 4, duly supported by all documents, agreement, work order, and evidence of discharge of service tax liability by the petitioner for towards payment of enhanced rate of service tax, enhanced rate of mid-wage payment. Stop. Let such decision be taken within a period of 6 weeks from the date of receipt of copy of this order. Needless to say, the petitioner is aggrieved by the decisions taken. We may invoke the remedy as is available in law.
For respondent number 8, my lord, my appearance may continue.
Mr. P.S. Pati for respondent number 8.
Obliged, my lord.
इसमें भी नाम कर रहे हैं इसको उसके साथ बैट वाले का
Item 29.
Because in this case, I am appearing for the petitioner, Meloj.
Yes.
Meloj, I was praying that this matter could be taken up on a physical day, Meloj, as the council from Delhi shall be assisting your lordships, Meloj, in this case, Meloj. Meloj, the matter relates to refund of advance VAT paid to the respondent number 4, as the sale has not fructified, Meloj.
Why can't it be posted on the same day on which the other matter for refund of excise and countervailing duty has been kept?
Yes, Meloj, similar matters as regards excise, the same petitioners have filed, Meloj. If your lordship pleases, Meloj, on the same day, Meloj.
But that case has been posted on a virtual day, perhaps, as per the request of Mr. Gulati.
Yes, Meloj.
Are you aware of which date the case has been
No, Meloj, I am not aware of the date, Meloj. And also, counter affidavit has been filed by respondent number 1, 2, 3, Meloj. respondent number 4 is not has not been issued notice in this, my lords. So I was also praying that in the meantime, my lords, if some time may be granted to file a rejoinder in this case, my lords.
Who is respondent number 4?
My lords, Jharkhand State Beverage Corporation Limited, my lords.
My lords, Mr. Ronak Sahai is appearing, my lords, on behalf of Jharkhand State Beverages Corporation generally, my lords.
His name is appearing?
No, my lords.
His name is not appearing, my lords. But he is appearing, my lords. I am sure, my lords.
Ask him to join so that we can direct him to file counter.
Ronak Sahai ko phone lagao. Yes, my lords. I'll just, my lords, connect to him.
You seem to have filed counter affidavit on behalf of all the respondents because you have not indicated as to which.
My lords, in fact, my lords, it is due to inadvertence, my lord, it has been filed only on behalf respondent state, my lords, not on behalf of the State Beverages Corporation due to inadvertence, my lords. My lord, due to inadvertence, my lords, I could not. रौनक साहब को फोन लगाओ ना, बुलाओ, खुद बुला रहा है.
Book date ये WPT 378 of 21 किस डेट को है देखिए तो 4.
My lord, it is fixed on 4th May, my lord.
Yes. Then on keeping it on 4th may not serve any purpose.
Because notice will go.
नहीं वो appear कर देंगे.
अच्छा appear कर देंगे.
This can await completion of pleadings. Yes, Mr. Ronak.
Yes, ma'am.
Yes, Mr. Ronak, you will appear for the Beverage Corporation of Jharkhand.
Yes, Millers. I am the retainer counsel for JSBC Limited.
Counter affidavit has been filed on behalf of respondent number 1 to 3. State respondents number 1 to 3. Stop. Mr. Ronak Sahai appears for the respondent number 4 and seeks 3 weeks time to file counter affidavit.
Yes, Millers.
Stop. Let copy of the pleadings be served upon Mr. Ronak Sahai by Friday.
Yes, Millers.
By learned counsel for the petitioner and receipt be filed. Stop. Let the name of Mr. Ronak Sahai appear in the cause list henceforth for respondent number 4. Stop. Learned counsel for the petitioner also seeks time to file rejoinder to the counter affidavit of the state. Stop. Matter be listed after 4 weeks so that petitioner may file reply to the respective counter affidavits of the state and the respondent number 4. Stop. This has prayed for by learned counsel. Learned counsel for the petitioner has prayed that you want it to be on a physical day.
I'll be grateful, my lords, if or any date as your lordship may please, my lords.
So in this case, any senior counsel is to appear or you would be assisting?
My lords, I'll be assisting, my lords, not a senior counsel, but a partner in the firm in Delhi would be appearing in this, my lords.
Very good. If possible, let the matter be listed on the date on which the court is functioning in physical mode.
I'm grateful, my lords.
Acknowledgements.
Item number 30. WPT number 5315 of 2021. Mr. Sumit Gaudia for the petitioner. Mr. Ashok Kumar Yadav.
Your Lordship, we will be seeking time for filing of the rejoinder in this matter, Your Lordship.
Counsel for the petitioner the Jalan Press form is allowed 2 weeks time to file counter affidavit. Rejoinder to the counter affidavit.
Your Lordship, 4 weeks time may be given. There is a bereavement in the family of the representative of the petitioner, Your Lordship.
4 weeks. 2 weeks means 4 weeks. Thereafter, holidays will intervene.
Obliged, Your
Please
Lordship.
take care of ये 31 और 33 से 35 सेम मैटर है उसके ऊपर.
Item 31, WPT number 5556 of 2021, Mr. Vikas Kumar for the petitioner, Mr. P.S. Pati, Mr. Amit Kumar for the respondent.
33, 34 and 35 को भी कॉल करिए.
And the item number 33, 34 and 35 also.
All these are GST on royalty matters.
Lordship, my lord.
My lord.
Yesterday itself, my lord, the order has been forwarded, my lord, the short order. The similar matter was taken up by your lordship 24/2022, my lord, last week itself, my lord. An interim relief was
order
granted
has
by
been
your
uploaded.
lordship. I've emailed it yesterday itself, your lordship.
So all these relate to not service tax, only GST on royalty, item 31, 33, 34 and 35.
Yes, sir. Lordship.
Lordship, confined only to
Relates to
GST.
GST.
Confined only to
Okay. All minor mineral lessees.
Lordship.
Yes, Lordship. Section 9 of.
So, short order or long order payment. Short order proposed for it. ये तो अभी जो उस दिन ऑर्डर हुआ है ना. छोटा ऑर्डर मिलता ना समराइज कर दिया.
My lord, I emailed it yesterday, your lordship. My lord, in serial number 35, I emailed.
Tag WP item 33, 34 and 35 along with the instant writ petition, as all of them relate to common issues, that is levy on GST, levy of GST on royalty upon the petitioners who are lessees of minor minerals in the state of Jharkhand. Start. Land counsel for the petitioners submit that this court, by order dated 20th April 2022, passed in a batch of writ petitions led by WPT number 432 of 2021, Mrs. Mandhan Mineral Corporation, Minerals Corporation versus Union of India and others, includes to grant interim protection from levy of GST on royalty. Stop. They submitted that the issues being constant, similar interim protection may be granted to the petitioners also pending final adjudication. Stop. Learn counsel for the respondent. Who are the respondents?
State and union.
Both state and union, both are there.
Yes, Lordship.
Learn counsel for this state of Jharkhand and ECGST both pray for and allowed 3 weeks time to counter affidavit in the respective writ petitions. Stop. 2 weeks time thereafter is allowed to learn counsel for the petitioner to file rejoinder if necessary. Stop. Since this court has, in consideration of the legal plea, since this court has been pleased to grant interim protection to protection on the levy of GST on mining lease/royalty to similarly situated persons. By order dated 20th April 2022, passed in WPT number 432 of 2021 and other analogous cases. Interim protection in the same manner is been granted to the petitioner's hearing. The operative portion at paragraph 9 of the order dated so and so is extracted here in below. List the cases along with WPT number 432 of 2021 and analogous cases.
I'm sorry, my lord. I'm sorry, my lord. I was before the Honorable Division Bench 1, my lord.
We have taken note of your case also,
My lord.
but we will request to each one of you whose writ petitions are there in these four matters to give a short one paragraph synopsis. Two are from the office of Mr. Kodia, one from Mr. Vikas Kumar, and one from
Lordship.
Yes, sir, Lordship.
the period concerned and the notice date and which district minor mineral lease. Only relevant. Very well.
Obliged, sir, Lordship.
Yeah, I think that you can call it. आज वाला
Item 32, WPT number 18 of 2022, Mr. Nitin Kumar Pasari for the petition.
In this case, I have just now received some email from the petitioner, my lord. They have sent some judgments and notes. I was only praying if it is passed over for the day. I've received it right now, my lord, 10-15 minutes back.
But I nominate Mr. Sandeep Choradia is there. He would be addressing the issue before my lord.
But I am appearing along with Mr. Nitin Pasari, my lord. The issue over here is that the SOCOS notice has been issued upon me without considering my submissions made before the authorities, my lord. Lordship, it comes down to page number 27, my lord, and 28, which is the legible copy of 27, my lord.
Yes.
My lord, on 21st of June 2021, my lord, the service tax department has issued a notice upon me, my lord. The respondent number 4, my lord, and the legible copy is page number 27, my lord. And thereafter, against this, my lord, in page number 28 itself, my lord, I have given a reply, exhaustive reply, along with the documents, my lord, which can be seen from page number 29, my lord. The transport work order, the work order given, transport document, sample copies of bill, my lord, every 26 AS profit and loss account for the respective year, my lord. My lord, thereafter, my lord, in page lordship comes down to page number 30, the legible copy of which is attached in page number 31, my lord. The next page, my lord.
Yes.
Copy, my lord. They again issue any documents from us. But against this, my lord, in page number 26, we have again replied 21. We have already submitted all those document consent, my lord. But this was to the respondent number 4. And in a precautionary measure, my lord, we have also written this letter to the principal chief commissioner, who is the respondent number 2, and the respondent number 3, the assistant commissioner, my lord. The letter appears in page number 32, 33. My lord, and their principal chief commissioner is in page number 34, my lord. My lord, thereafter, my lord,
Yes.
lordship comes down to, if your lordship comes down to, my lord, page number 37, my lord, onwards, which is the
Yes.
so-cause notice, my lord. My lord, 38, my lord, it
Yes.
is very, my lord, from the paragraph number 4. In order to further investigate the matter and allow the said notice to present the fact date, a letter dated 21/6/2021, my lord, was notice was issued on the to the noticee for submission of relevant relied upon document for verification. Due to non-compliance of the said letter, the subsequent reminder dated 13/7/21 and 1/9/2021, my lord, have also been sent. But even after issuance of 2 reminders, the noticee does not respond and not submit any desired document, my lord. Since the notice did not respond, our so-called and showed reluctant in submitting of desired information document after issuing several letters by the department. A summon under section 14 of the Central Excise Act 1944 was made applicable to service tax under section 83 of the Finance Act, my lord. And thereafter, my lord, going on, they have saddled a tax upon me of rupees near about 6 crores, my lord. My lord, repeatedly before all the respondents, I have been making a point that I have already filed those documents against the summon. I have appeared, my lord. I have placed all those documents. But in spite of that, my lord, my prayer is that to withdraw this so-called notice, my lord, to quash it and consider my representation, my lord. And if they want, they give a fresh notice upon me so that we can make an appearance on that day.
Why can't you respond to this so-called notice before them and make
My
that
lord,
same prayer before them?
Manad, the problem is, before this also, we have filed all those documents, Manad, required, Manad. Manad, they have not taken...
Is there any bar from them if they are not satisfied with your show cause notice and they say that you have failed to take registration and file statutory returns also for the
No,
FY
Manad, it is not, Manad. Manad, it is not, Manad. But the main predicament is that I have already filed all those documents, my lord. They ought to have taken cognizance of that, my lord.
So you get a better opportunity now to satisfy them in a proper proceeding.
My lord,
get a chance to appear and argue and submit your reply.
My lord, in that case, my lord, I'll be like
straight away. You see, if the straight away all so-called notices are being challenged, it's not without jurisdiction. Your grievance is that they have not taken into account your reply.
My lord, it is against the principle of natural justice, my lord.
So now they will follow the natural justice. Now, at the stage of summons, they may have an opinion. That's a one-sided proceeding. Now you get a proper opportunity in this quasi-judicial proceeding after issuance of SCN. And there are charges against you that you have not taken registration. These we cannot be asked to look into.
My lord, I have explained. My lord, I have explained the charge in page number 27 itself, my lord. But why I do not, why I am not taking any registration, my lord, it has been explained in 28, my lord.
We just want to know that if an inspection or a summon leading therefrom is being issued, does that mean that the respondents cannot initiate a proceeding under Section 73, under the relevant provisions of the Finance Act or Service Tax Act?
Lord, I am not stopping. Lord, I am not paying before lordship to stop the issuance of the summon, my lord. My lord, let my submission be considered and thereafter the summon be issued. My lord, I am not standing in the way.
Mr. Pati, are you appearing in this matter?
Yes, my lord, I am appearing.
So, let the petitioner submit his reply. You consider it properly.
Yeah, yes, my lord. Now, since the so-called notice is already issued, he may appear and he may submit his reply. The adjudicating authority will give him all opportunity and thereafter will adjudicate the case.
My lord, before the respondent number 4, respondent number 3, respondent number 2, repeatedly, my lord, as a precautionary measure, my lord, I have already stated that all the documents have been filed, my lord. Where the document has gone, my lord? Well, I asked a question to
whoever is the assessing officer
my
who
lord.
has issued the SCN, you respond to them. We can't get into all these issues, whether your documents are right, whether you have done everything correctly, whether you are not required to take any registration. That the
In that case,
assessing
my lord,
authority.
in that case, my lord, what I submit is circular number, my lord, 1076 of the Central Excise Regime, my lord, 1911, 2020, my lord. It says if there is a demand of more than so-called notice, if there is a issued upon the petitioner, if it is more than 5 crores, my lord, consultation hearing has to be provided, my lord.
Take all those points before the authority. That those points will be available to you even before the authority and at the appellate stage. We do not know at this stage whether it is offence related or preventive.
My prayer is, but what I pray is, I am not stopping them from issuing the so-called notice, my lord.
Then respond to it.
Some protection be given to me, my lord.
They are not going to realize the demand right now without an adjudication.
In this case, my lord, some protection be given to the petitioner, my lord, at least.
There is nothing imminent upon you, na? It's only a show cause notice.
You appear there, they'll pass adjudication order. Then only.
This is only a show cause notice. There is nothing imminently calling upon you. No garnishing notice, no demand.
But it is against their own circular, my lord. My lord, the CBs, the head body, my lord, the main body has issued a circular to the officer how to deal with this, my lord, so-called notices, my lord. Before that, a pre-consultation has to be given, my lord.
That is what we are saying, that we do not know at this stage whether it is offence related or relating to any preventive proceeding, preventive action, which is the exception under that circular.
My lord, the jurisdiction officer is not a preventive officer, my lord. My lord, he is a jurisdiction officer, my lord. Subject to correction, my lord.
Information comes from the preventive officer, because notice is to be issued by the jurisdictional officer, not by the preventive officer. You better appear and respond. In fact, the so-called notice is of October 2021, and you have approached this court after 2 months in January, and now it is being taken up in April end. It was pending. There was no defect also. Since 7 January, there is no such imminent threat upon you. This shows that there is no such urgency. Mr. Counsel, you better advise your clients, ask them to approach.
My lord, some protection, my lord, at least if they thereafter, my lord, also act in this manner, my lord, I'll be saddled with a huge burden of tax, my lord.
Mr. Pati, is there any imminent threat of realization?
No, I don't believe, my lord. It's a show cause notice which is yet to be adjudicated, and I have not seen, my lord, the central authorities taking any coercive measures.
In such cases? What kind of protection needs to be granted in such cases? It's at the stage of SQ.
But what I say, my lord, a date and time be fixed, my lord, so that I produce all those documents, my lord.
Perhaps he is saying that he may be the principles of natural justice may be properly adhered to. That your lordship may direct, my lord. That otherwise also the assessing officer is required to adhere to.
Suggest a date, Mr. Pati, on which he can appear.
Lord, any working day, my lord, your lordship may fix, my lord. They are duty bound. They will do it, my lord. He will appear.
Mr. Sandeep, we can fix any date in the next 10 days.
My lord, my lord.
देखिए, third learned
In
counsel
some,
for the
or in few cases, your lordship have also directed that the assessing officer will, adjudicating officer will put him to proper notice of a particular date. In some cases, your lordship
Yes,
have
yes.
passed those kind of orders without
Well, that
fixing
can
any
be done, my
particular
lord. That
date,
can be done.
directing the adjudicating authority to fix a particular day and put to notice to the SSC
My
that
lord.
he should appear on that particular day.
Third learned counsel for the petitioner, so and Mr. So and so appearing for the respondent, CGST. Stop. The petitioner has approached this court for the following reliefs. Para 1A to E. Stop. Petitioner has been asked to respond to the show cause notice dated 18th October 2021 issued by respondent number 2 so and so, asking him to show cause as to why tax along with interest and penalty of the stipulated amount under section 77(1)(a), 77(1)(b), 77(1)(c), 77(2) and 78 of the Finance Act 1994 be not realized from him, be not recovered from him. Stop. When counsel for the petitioner has inter alia submitted that the reply furnished by the petitioner, नहीं ऐसे लिखे, the petitioner carries on business in his individual name as a proprietor and engages in arranging trucks/tankers to transporters being goods transport agency on hire charges. The present dispute relates to the financial year 2016-17 and 2017-18 within bracket up to June 2017-18. By 2016-17. 16-17. यहाँ so called 16-17.
Well, 2015-16 to 17-18, my lord, up to June 17.
From the show cause, where does it appear?
My lord, page number 27, my lord. The legible copy is in page number 20, the next page, my lord. On the very top, my lord,
From the SCN, where does it appear as
my
to
lord,
the
my lord, my
relevant?
lord, my lord.
हर जगह पे 2017
No, it's in the ASC and it is only 2016-17, Malaj.
That's right. Yes. 2016-17. Stop.
16-17.
Learned counsel for the petitioner has submitted that the assessing authority did not take into account the detailed reply submitted by him pursuant to the summons dated 21st June 2021, Annexure 1, wide Annexure 2, reply dated 6th August 2021, followed up by The reply dated 15th September 2021, Annexure 4, before and Annexure 5 dated so and so. 18th October 2021, before issuing the show cause notice, the respondent authority has not taken into consideration the documents submitted by him before initiating the proceeding. It has also not adhered to the pre-show cause notice consultation in terms of para 5.0 of the master circular dated 10th March 2017 and 19th November 2020. No, sorry, 21st December 2015. Stop. As such, petitioner is being denied the been denied the principles of natural justice. Stop. Para. Therefore, interference is being sought at this stage by this court in exercise of writ jurisdiction. Appellant counsel for the respondent CGST, Mr. P.S. Pati, at the outset has taken a plea that the writ petition should not be entertained, may not be entertained, as it seeks to challenge at the stage and not be entertained at the stage of show cause notice, as the petitioners have not been able to show that the SCN is without jurisdiction. Stop. It is further submitted that the petitioner, the show cause notice contains the violations. The contents of the show cause notice reflects the violations committed by the petitioner. Stop. As such, he may be asked to respond to this SCN and submit his reply. Stop. He submits that the procedure prescribed under the Finance Act for shall be followed by the adjudicating authority. Stop. This court may fix a time frame for the petitioner to appear and respond to the show cause notice, which is of 18th October 2021, as he doesn't seem to have appeared and submitted his reply till date. Stop. Then counsel for the petitioner then submits that the petitioner is willing to appear on any date on which the court may deem fit. Stop. On consideration of the rival submission of the party, we are of the view that interference at the stage of SCN is not called for. Stop. Petitioner is required to respond to the show cause notice, appear and respond to the show cause notice before the assessing authority. Stop. The assessing authority shall fix a date and time for the petitioner to appear and submit his reply with all supporting documents through his authorized representative, through himself or his authorized representative by by 13th of May 2022. Stop. Needless to say, on his appearance and submission of reply, the authority, the concerned authority slash respondent number 2 shall proceed in accordance with law after due opportunity to the petitioner.
Grateful, Lordship.
Disposed of.
A pleasure appearing before your Lordship.
But the show cause notice has been issued.
Respondent number 2 is the issuing authority. Let it be made clear that we have not gone into the merits of the case of the party. दो केस को
इसमें करता हूँ कि इसे अपना वहाँ जमा कर देगा तो ऑटोमेटिक कुछ नहीं ये नंबर जी है लास्ट में इसमें मैंने एसएससी में अथॉरिटी he will submit the himself before SSC and he will fix it. Well, एक ही बचा
अंकल लिस्ट में किसका रिजॉइंडर? नहीं समझ में आ रहा है।
लिस्ट में है रिजॉइंडर की फाइल यहाँ फोटो नहीं लेना फोटो लेटर वाला
किस केस में? ये केस कल है, तो आज भिजवाने में क्या दिक्कत है? ले लीजिए। तो दूसरे आइटम बचा था। हाँ 15 और एक ये इंजीनियरिंग 27 दो आइटम बचा ना 15 को कॉल किया।
Possible case item 15, WPS number 1787 of 2020, Ms. Leena Mukherjee for the petitioner, Mr. Gautam Rakesh, Mr. Prashant Pallo.
Yes, madam.
Yes.
The petitioner that is against the order passed by the learned cat, page 52, my lord. The case is for my lord appointment on the basis of the disability certificate. The matter has been finalized, my lord, by the learned cat, as also one case was moved before the two cases were moved before the Honorable High Court. It was decided that 40% disability are entitled for the appointment in the disability quota. The petitioner made application.
In the last week,
yes,
similar matter was there in the, or some other matter was there in which we have.
No. That is, my lord, that is the matter of the appointment against the alternative post. I have given the judgment before your lordship. That is WPS number. That is WPS number 937 of 2015. I have given that judgment also. Or first, final order has been passed on 5/1/2022. That is another matter. That is against the medical candidate in alternative post.
दो सोर्सेस है वो दूसरा
criteria criteria
50%.
Kindly turning to page 34, my lord. Most of the candidate has been given employment on the basis of the disability certificate issued by the disability commissioner on the direction of the disability commissioner by the district medical board in the year 2016-17. And page 45 is the judgment, my lord, on that basis also that. And the law has been laid down that the certificate issued by the district level disability committee constituted by the by the direction of the commissioner will be effective and that will be enforceable throughout India. Not only the petitioner but also other persons also. That was decided in paragraph 94 is
Why has it been refused in your case?
my case has been deposed on an extraneous circumstances by saying at that time you have produced the medical certificate in which it was not up to the 40%. But my submission is that all the persons, those who are giving the medical certificate, that has not been accepted, questioning the genuineness of the certificate, and it is up to the mark. And when the case has been decided by this court, as also Honorable High Court and Calcutta High Court, the 40% will be the criteria, and that will be given. And this certificate issued by the district level committee, constituted by the commissioner, by the order of the commissioner, according to the Act, Disability Act, that will be given effective. My lord, kindly see the paragraph 94, which is quoted in the impugned order. Just, if your lordship so please, my lord. And the judgment which has been passed in the another cases, that is 43 to 45. My case is that, my lord, in all cases, appointment has been given on the basis of the disability certificate issued recently by the recently, that is 2016-17 onwards, in between the period, on the basis of the direction passed by this court. And that direction is quoted in the impugned judgment. If your lordship kindly turn page 56. Page 56.
So your was less than 40%.
At that time it was less than 40%, but it was not given by that was a certificate in the year 1993 before the Disability Act came into force. More so, that was not by the civil surgeon or the court. Therefore, in all cases, when you decline to accept the medical board certificate which was issued at that time by all the applicants, now they have accepted on the basis of the disability certificate. Therefore, whether they can deny to accept it in my case also. And kindly see the page 56, the disability percentage has been decided, and who will issue the disability certificate, that also decided, and for all cases that will be enforceable. Page 56, my lord. Paragraph 94 is quoted there. If I read, my lord, from 55, it will be better. We have gone through the pleadings of the heart, the argument of the learned counsel for the both parties. During the course of argument, the counsel for the applicant cited the ruling of the Honorable Apex Court in Maharaj Krishna. May I read it? My Lord, Maharaj Krishnachan of Hart versus State of Jammu and Kashmir, reported in 2008, volume 9, Supreme Court cases 24, in support of her contention that the authorities should have followed a decision of the court and granted similar relief to the person similarly situated.
Yes, Mrs. Paul, please carry on.
Yes, my lord. This has also again brought to the notice of the tribunal paragraph 94 of the decision dated 263 of 2009, which was quoted in the decision dated 24/8/2015 in way number 280 of 2012. The paragraph is reproduced here. Well, kindly see that. As it has been observed earlier, the disability certificate issued for a few of the 8 applicants before us are not accurate in the sense that they have not clearly stipulated the life of the certificate itself and as to whether it is in respect of the permanent disability or a temporary disability. However, these certificates are not accompanied by any declaration by the state government, while that is important, state government, of constitution of an appropriate medical board at the district level for the purpose of issuance of such certificate. In the absence of any mention of such authorization from the state government for constitution, a proper medical board from the body of the certificate issued by the district level dignitaries and the authorities, force of such certificate produced by the applicants as they appear to have been issued in routine course itself. It is therefore, my lord, that is important. It is therefore laid down, that is the law, that the respondent number 4, the State Disability Commissioner, shall forthwith notify the constitution of proper district level board in order to enable these applicants and any others. My lord, I am on that point because that case has been dismissed on that point. Only the judgment was so for the applicant before the court in that case. My submission is that these applicants and others who approach the medical boards and then their certificates and certify be enforceable throughout the country. Therefore, the matter it has not been challenged and they have accepted that on the basis of the disability certificate issued by the disability board, medical board, on the basis of the direction of the commissioner of the disability act, the bench medical board was constituted. On that basis they have been given in the year 2016 and 17. Therefore the plea,
Those whose cases were allowed,
yes,
and they were allowed to join.
Yes,
they had submitted disability certificate of 40% and more at the time of their provisional appointment also, and later on also the medical board confirmed that.
Yes.
In the case of the applicant, perhaps his certificate was less than 40%.
Yes.
Now he says that he is more than 40%.
My lord, kindly consider. Yes.
This is the distinction which has been drawn out.
Yes, they have been given. My submission, my lord, I put a question to myself. When if they have acted on the basis of the certificate given at that time, then I have no case. But when that law has been formulated and it has been throughout the India and for others also, therefore this certificate which has been given by the proper authority constituted in the direction of the commissioner, that is to be accepted as it has been accepted to all other cases. That is the similar case. And kindly consider, my lord, page 45. Just a minute, my lord, if your lordship kindly turn. Page 43.
Yes.
Page 43, my lord.
Yes, yes.
Yes, that is the judgment dated 13th October 2017. Have your lordship got it, my lord? And kindly see, my lord. Kindly see, my lord. Page 45. They moved several round of litigation up to the High Court, CAT, contempt, whatever may be. And the matter has been finalized, page 45, 45, paragraph 3. The paragraph 94 has been quoted. Am I right to say?
Yes.
Yes, which has been quoted in the impugned order itself. And kindly consider, my lord, that has been page 46. It is therefore laid down. Therefore, that is a mandate and that has never been challenged. Therefore, that it has been laid down. The respondent number 4, the State Disability Commissioner, shall forthwith notify the constitution of the proper medical district level medical board and in order to enable these applicants and any others. As I was in that group, therefore I also prayed for that. I mean that later my lord kindly see. certificate and letter, that is Annexer 4 series, my lord. Annexer 2 and 3, page 38 and 34. And the OA has been, my lord, page 46 and see paragraph 6. The OA, the applicant, have therefore sought a direction upon the respondent, the same prayer before the cat also, my prayer, to allow them to join their duties on the basis of the disability certificate issued by the medical board constituted by the State Disability Commissioner in view of the order dated 10th March 2011 passed by this tribunal, not to discriminate them and to extend the identical benefit of appointment under the handicap quota as extended similarly situated person being applicant of such and to act on the basis of the disability certificate. That case has been allowed and he has been, they have been, all have been directed to respondent to grant them suitable benefit in terms of the said certificate, that is page 48. That is, after the judgment, they have been appointed on the basis of the disability certificate issued on the basis of the direction in paragraph 94. And while I kindly consider my certificate, the Annexer 2 and 3. Annexer 2 is that, my lord. Just a minute. Annexer 2, page 38. And that is the letter of the commissioner, who is empowered according to Act under Rule 4. He is the only competent authority. Rule 4. उपायुक्त विषय का संबंध में कहना है कि जोगेंद्र फांसी पिटिशनर बिफोर योर लॉर्डशिप गत आवेदन दिया गया है जो दिव्यांग प्रमाण पत्र पेज 38 में डिसेबिलिटी सर्टिफिकेट पुनः निर्गत करने हेतु अनुरोध किया गया है, यद्यपि इनका 40% दिव्यांग प्रमाण पत्र निर्गत किया जा चुका है। 2004 में भी 40% था। अदो प्राप्त अध्यावेदन एवं कागज छायाप्रति विकलांग अधिनियम 1995 का प्रावधान का अंतर्गत वर्णित तथ्यों का आलोक में जांचकरण नियमानुसार 15 दिन के अंदर विकलांग प्रमाण पत्र दाखिल करे, निर्गत करे। And kindly consider the page 39. That is, the certificate by the board has been issued on 35/2017, and that is 40% and permanent. And you see the last line. उनके मार्गदर्शन सिद्धांतों के अनुसार उनके शरीर का अंक 40% अंक में स्थायी शारीरिक क्षति नेत्रहीनता था। And the persons, my lord, kindly consider the kindly turn, my lord, and page 34. 34. All are appointed and application made application is the same notification, and 9/1/2021, that is, fill up the post, group the post in the scale of such and such physical handicap quota in Chakradharpur division, page 34. In this case, my lord, kindly consider so many persons has been named, and as many as 20 persons has been given appointment in between the period, that is 2014 to 2016. Practically 2016, 16-17 on the basis of the medical certificate issued by the board in pursuance of the paragraph 94 of the judgment. Therefore, my lord, the stamp bearer has given employment.
Yes.
Ramnath Hota, serial number 2, he has given employment on the basis of that certificate, not on the basis of the certificate issued in the year 99 or 95 or 93. And my certificate, on what basis they have said, my lord, kindly consider. Kabir Kumar Vishwas, serial number 3, he has given. My lord, serial number 5, Vidyasagar Mahato, he has given. Then, my lord, serial number 8, my lord, Sri Manas Chandra Mahato, he has given. Then Chandrasekhar Rao, he has given. Then, my lord, Sanjay Kumar, he has given appointment. Guri Jadhav, his judgment is page 35, I have read now. Gopal Reddy, on the basis of the certificate. Then my name is serial number Yogendra Shasi, I have not given. And my lord, below my name also Jainika Bhattacharya, Raja Mikro, that is serial number 2 and 3, merit candidate, they had also given on the basis of the disability certificate. They have not acted on the basis of the disability certificate given at that time, rather they have acted on the basis of the disability certificate issued. And that they have acted on the basis of the 93 certificate. I should show before your lordship, that is my lord, Annex 7, page 59. Kindly see that. Page 59.
Yes.
That is also not by Annex 7, my lord, kindly see. Department of the Personnel and Administrative Reform. That is the medical certificate which has been given, that's less than 30, orthopedically 35 to 40 and 20 to 23 provisional certificate. And in that 94 paragraph, it has been stated that must be permanent or disability by the constituted board. And more so, my lord, this certificate 39/1993 was not according to the Disability Act, because the Act came into force in 1995, and rule has been framed in the 1996. And according to the rule, my lord, Rule 4, according to the Rule 4, only authorized to give disability certificate. Disability certificate shall be issued by a medical board duly constituted by the central and the state government. The state government may constitute a medical board consisting at least 3 members, out of which at least one shall be specialized in the particular field in for assessing locomotive, visual, and including the low vision, hearing, and special disability, mental condition, and leprosy caused as the may be. Therefore, my lord, the direction which was given under paragraph 94 is final, and that was never challenged, and they have acted on that basis. Now they can say that at that time your disability was below 40, therefore your appointment is concerned. And in all the cases, my lord, including my cases, appointment letter was issued in the year 2001, and they have been given appointment after so many litigation rounds of litigation only in the year 2016 and 17 on the basis of the medical board. Therefore, without giving any benefit on that point, if that is the case, they are 40%. Why they have not given the appointment at that time, even after filing the appointment letter? They have not given the effect to the appointment letter, only raising doubt of the disability certificate and the percentage also. Firstly, they say that should be 75. When the Honorable High Court confirmed that 45, then also twice their prayer was rejected. Again and again they have moved and came to a finality, and the 94 has come, then it has been accepted. And 93 certificate is not according to the rule, and 97 now the certificate which has been granted by the Disability Commissioner, that is page 39, that is 40% on service. Therefore, I cannot be discriminated after giving.
Since the year 2000, when he was provisionally appointed,
2001.
2001, he continued in service or he was removed?
No. None of the candidate was allowed to join. The name I have shown in page 35, none of the candidate was allowed to join on the basis of the certificate. They rejected the.
Why he approached the tribunal in 2019?
Because when the case has been before that also I moved before the case. That is in the mention in the annexal itself. I moved and the order was passed to dispose of the matter to extend the benefit of the same similarly situated person.
Where is that order?
Yes, that order has not annexed, but that has been deferred in the improved order 52. Kindly see that. However, it moved recently. On the page, and consider he moved earlier. Yes, page 53. The applicant earlier approached the tribunal by way number 164 2018. 18 he moved because the 17th matter has been finalized. which was disposed of with the direction to consider the representation filed by the filed.
2018.
Yes, my lord, 18 because the matter was finalized, my lord, 2017, page 45. Then is considered 43. The matter has been ended by order dated passed in the year 2017. Page 17, my lord. Page 43.
Yes.
That is the last order. And after that, they are allowed to join. Their appointment letter was issued in the year 2001. And on the basis of the disability certificate issued by the board in terms of the 94, paragraph 94.
Delayed हुई है ई सर्टिफिकेट में 50% तक कम था वो लोग सबमिट किया उसका 40% से ऊपर था उसको भी नहीं मान नहीं रहा वही बड़ा क्लियर डिस्टिंक्शन किया
Yes, my lord. Therefore, my submission is after extending the benefit to join their duties on the basis of the disability certificate issued by the duly constituted medical board in the year 2016, 17, whatever may be, whether they can discriminate me only by saying that your application was none of the cases they have given effect to the certificate issued in the year 1999 or before that, which was produced by them. They have acted on that basis. I am relied upon that judgment, my lord, that is 2008, volume 9, Supreme Court cases, page 24. 24. When the judicial pronouncement it has been held, my lord, that all the others also, and that will be applicable all over India, they can't say that this certificate is not being accepted, not be given effect to only because it was submitted now, and at that time it was below 50. None of the cases they acted on the basis of the certificate submitted at that time. And in this judgment, my lord, it has been said they ought to have graciously accepted it by granting similar benefit to the present petitioner. It is not required to move each and every petitioner and file so many litigation for a conclusion which has been held by this court and came to its finality. They have not challenged this. That is my submission. And I have stated in my paragraph, my lord, that all the persons have been appointed on the basis of the recent state level medical board report. They have not given any reply. Rather, they have accepted that appointment has been given on the basis of that. No para-wise comment has been given. I have given the name also who have been given appointment. In the read petition also, 18 or 21 petitioner named in the notification has already been appointed. They have not given any reply to the effect.
Very well. Yes, respondents counsel.
My lord, if it may please the court, my lord. My lord, the petitioner had applied for the post of handicap. If my lord may come to annexure A of my counter affidavit, it shows that the petitioner had applied in the category of visually handicapped.
Yes.
Point number 7, it mentions nature of physically handicapped, VH, that is visually handicapped.
Yes.
Now, my lord, the appointment in 2001 was on a temporary basis, and it was clearly provided that it will be subjected to the outcome of the medical examination that will be done by the railways. That is provided in Annexure B, page number 22, my lord.
Yes, yes.
Then, my lord, the certificate that was given by the petitioner, that is on Annexure C, page number 24, my lord.
The orthopedic disability was 35 to 40%, my lord. However, the visual hand disability was only 20 to 30%. That is
Yes.
indicated at page number 25, my lord.
Yes.
My lord, if we may come to the rejection order, that is at page number 50 of the writ petition,
Yes.
annexure 5, relevant is page number 51, my lord.
Yes.
The reason why the representation of the petitioner was rejected is clearly provided in this rejection order, my lord. My lord may look into para number, may I place it, my lord, para 1 of page number 51.
Yes.
In response to the employment notice dated 10th of February 1999, you had applied for recruitment in Group D post against visually handicapped category, while your application dated 26th of March 1999. Thereafter, you, along with other candidates, were called to appear in the Viva Voice test held on 12th of December 2000 on the basis of selection held for recruitment of physical handicapped persons in Group D category. The selection committee prepared a panel of selected candidates of PHP, including visually handicapped, against the 3% quota reserved for physically handicapped persons. You were provisionally impaneled against the VH quota under panel number E, Recruitment Group D, PHP 3, dated 9th of January 2001, along with other candidates. Subsequently, offer of appointment was issued and you were sent for medical examination. Now, my lord, the next para will be relevant. However, during the verification of medical certificate issued by the civil surgeon Chaibasa, it was noticed by the senior DMO Chakardarpur that your orthopedically disability is shown as 35 to 40% and visual disability is shown as 20 to 30% only. As per rule for recruitment against VH quota, 40% disability is required, which you do not possess. Accordingly, your candidature was not considered. On contrary, the candidates now, my lord, the distinguished the other candidates who have been given appointment on the basis of the medical board certificate issued in 2017 are distinguished from the current petitioner, my lord. On the contrary, the candidates to whom appointment has been given against visually handicapped quota in terms of the order passed by Honorable Tribunal had initially submitted handicap certificate wherein the percentage of the disability was shown as 40% or above. Now, my lord, this may be noted, the candidates, namely Vidya Sagar Mehto and others who have been given appointment in 2017, their disability certificate at the time of temporary appointment in 1999 also provided that the disability percentage is 40%. However, the disability percentage of the current petitioner only provided 20 to 30%. Now the petitioner is relying on the certificate issued by the medical board in 2017, my lord, that is at page number 39 of the writ petition, annexure 3. Now, what has to be noted, my lord, that the appointment was to be held in 1999. At that time, the disability percentage was 20 to 30%. And after a period of 18 years, when again the disability, when again the medical examination of the petitioner has been held, it has been 40%. However, my lord, there's a lapse of 18 years that has to be taken into account. The reason for rejection of the representation of the petitioner has clearly been provided in page number 51 of the writ petition, that is the order of rejection 1st of November 2018. The Honorable Tribunal had also rejected the claim of the petitioner, the OA filed by the petitioner on similar grounds. My lord,
Yes.
if my
So
lord,
the candidates who have been granted appointment later on, after the orders of the tribunal, initial certificates were above 40% disability.
My lord, in
That was
1990,
that was affirmed after the examination by the medical board as per direction of the CAT.
my lord, in 1999 also, their certificate showed a disability percent of 40%. And after the examination that was held in 2017, as per the directions of the Honorable Tribunal, then also their disability certificate showed a disability of 40%. However, this is not the case with the current petitioner.
Yes, yes, understood.
Yes, my lord. In this case, my lord, there is no question to affirm the disability certificate produced in the year 2093. My lord, case is that no, my lord, then why 18 years they have not given the appointment? They have not acted on the basis of the certificate given in the year 1999, 2000, whatever may be. Not for any single candidate. They disregard that question that disability certificate. Then only so many rounds they have to move before the court of law. And when it has been finalized by 94 of the paragraph that the disability certificate must be given by the district level committee on the basis of the direction of the commissioner, and only not only for the applicant and the others also, and that certificate will be valid all over India, and that will be enforceable all over India. They have acted on the basis of the certificate issued after the judgment passed by this court, and they have accepted, and on that basis. It is not the certificate which has given earlier that has been affirmed. That has been affirmed. In any cases, that was no question of affirmation, that is issuance of the fresh medical certificate on that basis. Then I may put a question myself: if it is accepted, they
Very well.
my lord, one thing I want to show, my lord, this disability certificate and the provision to give employment is a beneficial in legislation. And so far, the disability person, if they have to move from six times down, seven rounds before the court of law, and that the matter was finalized, they acted on that basis without any examination of the medical officer of the railway. How they can deny it to my case? And when it has been done in the year 2017 also, may I kindly consider the 17 judgment I have shown here before your lordship.
Yes.
Therefore, that is arbitrary discrimination, and they can't say that there is no question of affirm of that certificate which was issued in the 1993. And my application, my lord, appointment was never cancelled. And all the persons.
Very well.
Yes, Malan, and our judiciary is not for, only for equality, Malan, that is for the court of equality also. The disabled persons who are suffering, and Malan, their appointment letter was never cancelled. In all cases, appointment letter was issued in the year 2001, and that was never rejected, but not allowed to do. That is my submission, Malan. He is entitled for the same benefit or otherwise Article 14, 16, and 21, and the decision of the Honorable Supreme Court also. They should have gradually extended the benefit to all persons, those who are facing that problem, and they should accept it. And after the judgment, there is no question at all to give effect to the certificate which has been given in the year 1993, that is before promulgation of the Act also. And that is not by the board, my lord. I have shown that is district reform, Department of Administrative. Much obliged for it. That is
Let's hear counsel for the petitioner and then counsel so and so for the Union of India. Order reserved. Yeah, I say
Obliged, my lord.
Close the case under the heading for orders on 5th of May 2000.
As it.
Obliged, my lord.
Much obliged.
Item number 27, WPT number 3133 of 2021, Mr. Manoj Kumar Chaudhary, for the petitioner, with the PS Patel.
My lord, item number 27.
Yes, yes, yes.
My lord, I am appearing for the petitioner.
Yes.
My lord, there is a huge service tax demand of 20 crore 13 lakh on the sole ground that stamp duty was not adequate. Stamp duty paid on the agreement, 3 agreements with Jharkhand government was not adequate. That's the only ground. And if my lord have a look at the stamp duty, my lord should not take more than 5 minutes to consider that the so-called notice does not lie because no stamp duty is payable on any agreement signed by the state government, any government.
Yes.
My lord, may I have a look at page 6 just to have a glimpse of what the issue.
Yes, which page?
My lord, page 6 of my petition.
6.
Page 6 of my petition. I have extracted.
एक पेज में 24 लाइन से ज्यादा नहीं है। थोड़ा तो पूरा में चेंज करना इफेक्ट वो है भी नहीं फॉन्ट के बारे में Page 6.
Yes, my lord. Page 6 of my petition. I have extracted section 3 of Indian Stamp Act. Section 3 of Indian Stamp Act, I have extracted. I read that instruments chargeable with duty, subject to the provisions. My lord has got it.
Yes.
Section 3, instruments chargeable with duty, subject to the provisions of this Act and the exemptions contained in Schedule 1, the following instruments shall be chargeable with duty of the amount indicated in that schedule as per the proper duty, therefore, respectively. That is to say, A. Every instrument mentioned in that schedule which not having been previously executed by any person is executed in India on or after the first day of July 1899. My lord, next two we may not consider because they are not for our purpose. Then proviso. Provided that no duty shall be chargeable in respect of any instrument executed by or on behalf of or in favor of the government in cases where, but for this exemption, the government would be liable to pay the duty chargeable in respect of such instrument. That means an instrument signed by or for the benefit of the government is not liable to stamp duty. And all the 3 agreements.
Yes.
My lord, all the 3 agreements are signed by Jharkhand government for construction of engineering college and polytechnics on behalf of the Jharkhand government. All along service tax has been exempt. We have never paid service tax. We have not taken registration for service tax, but it has been exempt all along. And all the three agreements, incidentally, have been signed on non-judicial stamp paper, 200 to 230 rupees. But the department is not saying why that whatever is stamp, maybe out of abundant caution, it has been paid, it has been signed on stamp paper. What is the amount payable and what is inadequate, and for which the exemption is to be denied. The exemption has a condition that it should be signed before 2015 and adequate stamp duty wherever applicable has been paid. In our case, it was not payable at all, though it has been signed. My lord may have a look at those agreements, three agreements on which the entire demand has been raised. Page 66.
66.
Yes, my lord. This is part of the so-called notice itself.
Yes.
This is the memorandum of understanding between the government of Jharkhand and Engineering Projects India Limited. We are a PSU. And this is for construction of these polytechnics. The next agreement is, and my lord, here, if we just see the pages, first page is 100 rupees, second page is 100 rupees, then 10, then 10, then 10. 230 rupees has been paid stamp duty, though it was not payable at all. And then next agreement is at page 72.
Yes.
This is memorandum of understanding between Government of Jharkhand and Engineering Projects India India Limited. Now, this is also first page 100 rupees, second page 100 rupees, 200 rupees as stamp paper. It has been written, and this memorandum incorporates the earlier memorandum. Then the third agreement, which has been relied upon by the department, is page 74. This is page 74. This is again between the Government of Jharkhand and Engineering Projects India Limited. First page is 100 rupees, second page is 100 rupees, then 10, then 10, then 10. So 230 rupees. This was the earlier, my lord, this was the earlier agreement which has been made part of the second agreement. The third agreement on which Reliance has been placed, that is at page 79. Page 79, this is third agreement.
Yes.
This is again between Department of Science and Technology, Government of Jharkhand and Engineering Projects Limited. This is first page is 50 rupees, second page is 50 rupees, third page is 50 rupees, fourth page is 50 rupees, so 200 rupees. Stamp paper, it has been signed. First thing, that stamp duty is not payable. So out of abundant caution, it has been written on stamp papers. Second, it is the duty of the department to say if it is inadequate, how much was payable, what is the shortfall, and which we have not paid. They have simply said that the assessee has not been able to establish that adequate stamp duty has been paid. So these are the three agreements. The allegations which are there in the so-called notice, my lord may turn to page 35.
Mr. Counsel, you explain all this to the authority, assessing authority.
No, my lord, if we go through their reply affidavit, counter affidavit, it will show they have not understood Stamp Duty Act and they are not willing to understand. In respect of this exemption, what they have replied, I may bring to my lord's attention, their counter affidavit. They will never understand. And this is only on this issue. We are not going into Finance Act 1994 or all the service tax interpretation, only on stamp duty.
Very well, so you explain it.
You already
My lord, may have it, just have a look at the counter affidavit. What they are responding to this exemption provision.
They say that you are not exempt.
We are saying we are exempt under Stamp Duty Act, Section 3, proviso. And what is their response, my lord? I will just take 2 minutes to read. This is page 13 of their counter affidavit. Page 13 of their counter affidavit.
Yes, yes.
Page 13, my lord. Page 13. Paragraph 11.
Yes, what do you want to read out?
Page 13, paragraph 11, my lord. This is their response to our claim that it was exempt, no stamp duty was payable. Paragraph 11, I read that in reply to the statements made in paragraph A1 of the grounds in the writ petition, it is humbly stated that the petitioners themselves quoted section 3(1) of ISA, Indian Stamp Act 1899, which states that any instrument executed by or on behalf of or in favor of the government in cases where, but for this exemption, the government would be liable to pay the duty chargeable in respect of such instrument. On scrutiny of the said provisions, it appears that payment of stamp duty is exempted only if government is liable to pay the duty in respect of any such instrument. In the case of the petitioner, as per the agreement, no records establishes that the government of Jharkhand is responsible for payment of stamp duty. Thus, the agreement between the petitioner and the government of Jharkhand is not exempted from payment of stamp duty at the appropriate rate as per the Stamp Act 1899. The agreement itself is taxable without that exemption. The exemption has been provided for the agreement signed by the state government. What more evidence is required? My lord, this is a fit case for writ jurisdiction because only stamp duty is involved. Stamp duty law is involved, and they are not able to understand this.
Their understanding is that even in your agreement, the liability to pay stamp duty was not on the government but upon you, and you are not exempted. And you are not exempted under the two notifications also, because one of the conditions is not fulfilled. Therefore,
my lord,
yes.
My lord, the condition of that stamp duty exemption is that any instrument signed by the state government, but for this exemption, it would have been payable by the state government. And section 29M, 1M, I have given in my counter affidavit, states that anybody who is executing the instrument is liable to pay the duty. If state government is the instrument, the state government is liable to pay the duty for which the exemption has been provided. My lord, in my counter affidavit, I have extracted 29M of this Stamp Duty Act, and it says that the executants are liable to pay duty.
Mr. Counsel, you explain all this before the assessing officer.
My lord, they have already closed their mind for the reply. It's because there is nothing more required.
My lords, when a writ petition will be filed, reply has to be filed.
In that case also, suppose we decide it against you and express an opinion that will go against you and ultimately may have some bearing upon the adjudication proceedings.
No, my lord, only because this itself will decide the whole thing. But this is a writ jurisdiction, we are challenging the notice itself will go.
No, notice
the interpretation.
This is not without jurisdiction.
Notice is not without jurisdiction. The adjudicating authority has to decide whether your claim that you were not liable to pay stamp duty and therefore you were exempted and not liable to pay the service tax also is right or wrong. That is decision based on consideration on the merits of and the notifications.
My lord, here the prima facie, it's without legal foundation. This is simple argument of stamp duty law.
This is one point, this is one side of the view. Na? The other side of the view is that no, you were liable to pay stamp duty even if your agreement was prior to 1st March 2015. That would enable you to claim exemption, which you have not done. Isn't it, Mr. Ratnesh?
My lords, so far as this law is concerned, there are 3 notifications. The first notification was the mega exemption notification of 2012, by which, my lords, the exemption was there. Now came the notification of 2015, by which the exemption was taken away. Thereafter, the most important notification of 2016, that is notification number 9 of 2016, it says that there should be 2 conditions which should be fulfilled for taking exemption in such cases. And the 2 conditions are that the first, the agreement should be prior to 1st March 2015, which they fulfill. Number 2 was, and on which appropriate stamp duty where applicable has been paid. Our contention in the counter affidavit, because, my lord, the Honorable High Court is being called for under Article 226 to adjudicate the matter at this. But the contention in the counter affidavit taken at this stage is that the stamp duty is payable in these agreements. And this not having been fulfilled, the 2 mandatory clause, out of those 2 mandatory clause, one not having been fulfilled, the exemption notification, the benefit cannot be availed by the petition. How that is mandatory, that I have explained in my counter affidavit. If your lordship asks, I will demonstrate that also by the Indian provisions of Indian Stamp Act.
We do not want to be drawn into the merits because...
That is why, my lords, if the lordship wants, I will demonstrate it by the provisions of Indian Stamp Act. This is the dispute.
Who is providing the service? The government is providing the service or the petitioner is providing the service? Who is the service provider in this case?
Service provider is the petitioner.
Petitioner.
So, therefore,
Liable for tax.
He is liable for tax. If the conditions are fulfilled, he is exempted. You better approach, Mr. Counsel, tell your client.
Well, here the instrument is exempt, not the persons. The moment state government signs, the instrument itself is exempt from the...
That is not the understanding of the department.
That is not good. Either you withdraw or we will dismiss it.
My lord, this is a fit case for interference by this honorable bench.
We are not inclined. If you seek liberty, then we will not pronounce on the merits. Otherwise, our observations might prejudice your case before the assessing authority. Or at least a semblance of our view might be reflected from our order.
Well, the stamp duty law, they will never understand. Because this is, I will say, evident from their counter.
They will not. You are the service provider.
Yes, my lord. We have never.
Therefore, how you
never
will be
paid,
exempt?
sir. My lord. The so-called notice will not stand because the very basis is not there. State government contracts are not liable to tax, stamp duty.
Inconvenient.
No, Mr. Counsel, as you say, either you withdraw and approach the authority, otherwise we are not convinced. And that too at this stage, if it comes through the hierarchy of the assessing authority and appellate authority, and then the view is to be tested on purely legal principles, then there is a different stage.
My lord, we have to pay a huge amount of deposit for filing an appeal. And appeal
that is
nowadays
actually the worry of every petitioner.
That's
a 20 crore demand. We have never paid a tax at any point of time. And it would have been reimbursed to us by the state government.
That's the main worry of it. 250 rupees to fight Article 226. Yeah.
252.
50. Right.
27 will
Yes.
And still there is no adjudication order. Many petitioners come after adjudication order, but here there is no adjudication order at all. Nothing has been finalized. Nothing has crystallized.
The moment
it is only a counter affidavit.
The moment adjudication order is passed, 20 crore demand. And no other assessee has been penalized like this. We have never paid tax earlier, service tax earlier.
So that cannot be a ground. No? That is.
I'm just saying that whether the alternative is a efficacious remedy and whether this is a fit case for the interference of this court, because this is only a single issue on which the entire so-called notice depends. And prima facie, it shows that it was not payable at all.
All that we have understood is up to you.
My lord, I am in your, my lord's hands. Whatever my lord may decide. Only on stamp duty law, if it is decided, everything will go.
Third learned counsel for the parties. Petitioner has approached this court on issuance of show cause notice dated 27 December 2020 and 7 issued by the respondent number 1. Annexure 1. Asking it to submit, calling upon them to show cause as to why not service tax liability, including cesses within bracket, and other taxes and cess and other cesses be not demanded and recovered from them by invoking the extended period of demand as envisaged under the first proviso to subsection 1 of section 73 of the Finance Act 1994, read with section 119 of chapter 6 of Finance Act 2015, section 161 of chapter 6 of the Finance Act 2016, section 95 of Finance Act within bracket number 2 2004, section 1 and section 140 of the Finance Act 2007, together with interest at the applicable rate under section 75 of the Act and penalty in terms of section 78. They have also been asked to show cause as to why penalty be not imposed upon them in terms of section 77 of the Finance Act 1994 for having failed to get themselves registered with the Service Tax Department. Stop. The show cause is based upon an inspection carried out on the petitioners and the contract agreements entered into by the petitioner as service provider. During investigation, petitioner submitted clarification on 6 November 2020, as per which it claimed to have entered into construction/renovation of agreement of educational institutes with respect to 3 MOU/agreement between the petitioner and Government of Jharkhand. Respectively dated 28th February 2007, 7th March 2012 and 20th June 2014, all of which are enclosed to the writ petition. Stop. Petitioners claimed benefit of exemption notification number 25 of 2012 dated 20th June 2012, read with notification number 6/2015-ST dated 1st March 2015 and notification number 9 of 2016-ST dated 1st March 2016. According to the petitioner, all the MOU/agreements entered with the Government of Jharkhand were entered with the Government of Jharkhand prior to 1st March 2015, and as such, they were entitled to exemption terms of entry number 12, within bracket small c, small I, read with 12A, capital, within bracket small b, small I. Of the notification number 25 of 2012. Stop. Later, by an amendment carried through notification number 6 of 2015, dated 1st March 2015, exemptions provided under serial 12A and C were withdrawn and the services were made taxable. Subsequently, the exemptions were restored with retrospective effect by notification number 9 of 2016, dated 1st March 2016. Given
This
effect.
12A. 12A came in. 12A was an entry which came in 2016. Earlier in 25, the first notification of 2012, only 12 was there. Entry number 12 was there. The Lordship has stated 12 and 12A both.
In your show cause at page 32, this is written at the bottom.
Page 32.
As per section 102 of the Finance Act 2016. According to the petitioner, therefore, all the projects were exempted from levy of service tax.
Okay, well, actually 12 small a. I got confused.
No, small a only.
Small a, that is correct. 12 capital A came in 2016.
16.
Statement of the official of the petitioner company was recorded under section 70 of the CGST Act 2017, read with the relevant provisions of the Central Excise Act 1944, section 83 of Finance Act 1994, and section 173 and 174 of the CGST Act 2017. It was taken note that petitioner was not centrally registered with the Service Tax Department. It was also taken note that the above three MOU/agreement mentioned the various works to be executed by the petitioner through its subcontractors, but the value of work was not mentioned in those agreements/MOU. Petitioner prepared estimates and submitted the same to the government of Jharkhand, which in turn gave approval of the same. So thereafter, petitioner company floated tenders for various works and appointed subcontractors to execute the job. Stop. Details of the MU have been also mentioned in the show cause. As per the statement of the officials of the petitioner company, the construction work undertaken by the petitioner for Government of Jharkhand against the 3 March MOU/agreement was of project management consultancy, and it was a task to execute, design the project, preparation of estimates for completion of work, timely completion of projects, etc. For that, petitioner was expected to get a fixed percentage of projects as PMC charges. Stop. Upon submission of invoices to Government of Jharkhand for executed work, including PMC charges, payments were to be made. The nature of work executed through its subcontractors for GOJ against each individual projects fell under the master MOU fell under the category of works contract services. However, the petitioner had not paid any service tax on the value of the works subcontract services provided by them to GOJ. During investigation and during investigation, petitioner participated and took the stand of exemption under the notification dated 1st March 2016. Stop. However, the adjudicating officer, on being dissatisfied with the explanation and after scrutiny of the master projects and the relevant legal provisions under the Finance Act, under which the show cause notice was issued. Stop. So cause notice was issued as the petitioner had failed to deposit the service tax and also not got registered under the central service tax with the service tax department. Stop. Then counsel for the petitioner has referred to section 3 of the Indian Stamp Act 1899, especially the proviso thereunder, and submitted that the instrument executed by or on behalf or in favor of the government are exempted from payment of stamp duty. Stop. Respondent in their counter affidavit have contested this plea. Inter alia made twofold submissions. Then counsel for the petitioner, then counsel for the petitioner submits that since the leviability of the service tax is in question, the impugned show cause notice is being against the provision of law is fit to be quashed. Stop. Respondents have filed a counter affidavit. Stop. They have taken twofold. In respect of the claim of the petitioner, they have taken respect of the petitioner vis-a-vis respect of the claim of the petitioner for exemption from payment of stamp duty, it is submitted that as per the notification dated 1st of March 2016, two ingredients were required to be fulfilled. The notification dated 1st March 2016 revived the conditions of exemption stipulated under the notification number 25 of 2012, but exemptions could only be granted in favor of the petitioner if appropriate stamp duty had been duly paid on the agreements executed before 1st of March 2015. Though petitioner fulfilled the first condition relating to execution of the MOU/agreement prior to 1st of March 2015, but had failed to pay the appropriate stamp duty to claim the benefit of exemption for the services mentioned under para 12A and C. Stop. It is submitted that petitioner is working on a mistaken notion that under Section 3 of the Indian Stamp Act 1899, petitioner is liable, excluded from payment of, exempted from payment of stamp duty since the MOU/agreement has been entered with the government of Jharkhand. Stop. Respondents contend that exemption cannot be claimed by the petitioner who is a service provider to the government of Jharkhand, and after getting the work from the subcontractors. Stop. Therefore, it cannot avail the benefit of exemption relying upon Section 3, proviso to Section 3 of the Indian Stamp Act 1899. Yeah, the Stamp Act. Stop. Para. The petitioner should therefore subject itself to the adjudicating authority and submit its response. Stop. The show cause notice is the assessing the issuance of show cause notice doesn't suffer from want of jurisdiction for calling for interference by this court under Article 226 of the Constitution of India. Stop. Petitioner cannot escape the procedure and the alternative remedy prescribed under the law for under the law, and instead avail the remedy of writ jurisdiction. Stop. We have taken note of the submissions raised on behalf of the rival parties, but we consciously refrain from observing on the merits of the contentions regarding levy of service tax an exemption from payment of stamp duty claimed by the petitioner at this stage in exercise of our writ jurisdiction. At this stage where petitioner has only been asked to submit its appear and submit its response to the show cause notice. Stop. The show cause notice doesn't suffer from want of jurisdiction. Stop. The plea of the petitioner requires scrutiny and examination of service contracts entered both with the government of Jharkhand and its subcontractors. In the light of the exemption notifications. Stop. Whether petitioner would be liable to pay service tax on its claim or not, on its claim of exemption from payment of service tax as a stamp duty, is a matter to be decided at the first instance by the adjudicating authority. Stop. The question does entail adjudication on mixed question of law and facts. Stop. We are therefore of the considered view that the writ petition is not fit to be entertained. Stop. However, the petitioner is at liberty to respond to the show cause notice and submit its reply with supporting documents before the adjudicating officer. Stop. Needless to say, the adjudicating officer shall consider it in accordance with law and the procedure prescribed under the Act within a reasonable time frame. Writ petition is dismissed. Writ petition is accordingly dismissed.
Look, my seniors and my name will be recorded for CGST.
Achha, Mr. P.S. Pati and Mr.
Obliged, my lord.
Obliged.
Very well. If you see.
उसका कोई ख्याल नंबर 5 में है ना उसको भी लिखा है उसको भी वो खाता है हो जाएगा नहीं ठीक है ऊपर वाला कम
Very well. एक जजमेंट उसमें ऐड कर दीजिएगा मगध सुगर वाला वेरी वेल
Obliged, my lords.
Obliged, my lord.
नहीं रखना भाई उषा मक्के वाला कल 5 हाँ 2 को होना चाहिए नॉर्मल